Hello and welcome to CII's webinar, Protected Activity and Employee Protection in Nuclear Construction. We appreciate you taking the time to join us. I'm Mike Pappas, CII's Associate Director for Deployment. If you look in your GoToWebinar control panel, you'll see a gray bar labeled Questions. Please feel free to enter your questions there and we'll address them after the presentation. With us today, we have Tom Saunders, the Site Oversight Director for Vogtle Units 3 and 4 for Southern Company. Tom, thank you for joining us.
Hey, Mike, thank you for being here today and for hosting this webinar. A special thanks to CII for hosting the event today and to the folks on the line and who joined us as well. Thank you for the opportunity to share my experiences with you on this subject matter with the membership. And I believe that everybody that's taken the time to join us for the conversation today is going to be able to take away some new information and hopefully leave them with a better understanding of protected activity, what it is, what it means, and how it relates to employee protection. I'd like to take a minute at the start of the conversation to make sure that everybody's on the same page regarding nuclear safety. This is a fundamentally different concept from the standard industrial and personnel safety that all construction personnel are going to be familiar with. And it may be a new term for those of you who spend most of your career in oil and gas or in traditional fossil generation construction or other large industrial projects or non-nuclear work. It's just a different nuance that when I came to the nuclear construction side of the business about 10 years ago, it was something for me to pick up and learn and I guess make sure that I could differentiate between industrial and personnel safety. So with that said, nuclear safety is defined by the IAEA, the International Atomic Energy Agency, as the achievement of proper operating conditions, prevention of accidents, or mitigation of accident consequences that result in protection of workers, the public, and the environment from undue radiation hazards. So the fundamental tenet of all of this is to say that we want to prevent a release of radioactive material into the public domain. That's the fundamental underlying principle behind nuclear safety. And a key component of that nuclear safety is establishing and maintaining a strong nuclear safety culture so that an organization's values and behaviors, their leadership's behaviors, all of that is internalized by the members, by the employees and the workers and the leadership. And that serves to help ensure that nuclear safety becomes an overriding priority for the entire organization. And because of the special properties of nuclear materials and the unique hazards of the technology, including special byproducts, including high concentration of energy in the reactor core and the decay heat associated with a shutdown, nuclear sites in general are required to have a strong safety culture. And so that culture will allow the organization to establish and maintain a safety conscious work environment where everyone has the freedom to raise concerns without any fear of retaliation or retribution. And, you know, it's important to understand also that nuclear safety, it's a collective responsibility. It doesn't fall just on the leadership, doesn't just fall on the senior station manager, the site executive. No one in the entire organization on a nuclear project, a nuclear site, a nuclear job, whether it's a new power plant construction, whether it's a medical isotope facility, you're not exempt from your obligation as a nuclear worker to ensure safety first. And I'd like to refer you to a document from INPO titled Principles for a Strong Nuclear Safety Culture. Feel free to Google that if you'd like to. It's on the INPO website, it's on the NRC website. If you'd like additional details around how to help build, foster, and maintain a strong nuclear safety culture. And so with that kind of housekeeping out of the way, I want to get into the meat of the conversation today around protected activity and employee protections and how that relates to safe construction in the nuclear safety sense for a nuclear construction job. A foundational priority of management in the nuclear industry, again, has to be that you ensure a healthy safety culture and a healthy safety conscious work environment exists, and that you foster and nurture that through your words and actions as a leader and as an individual contributor. A focus on protected activity and associated employee protection provisions is critical to maintain the right balance and to ensure that all employees continue to feel free to raise safety concerns without fear of retaliation or retribution. So what is protected activity? Protected activity is defined as an individual providing information regarding potential or alleged violations or non-compliances around the regulations that govern the license that you've been given to operate or construct by the NRC. There's very specific employee protection provisions and requirements that relate to the rights afforded to individuals who engage in protected activity that are basically designed to prevent discrimination and ensure that any alleged violations or non-compliances to the policies are given the full and necessary consideration of the impacts of those actions to the health and safety of the public. Again, back to preventing a release of special material. That's what we're trying to do here, is our fundamental underlying tenet of all our management structures and strategies. Utilities, service companies, construction contractors, and other organizations who engage in providing services to, supporting, building, or operating nuclear facilities routinely leverage broad skill set across the nation of professionals who work throughout the nuclear industry. And those same organizations operate under the guidance of different processes and protocols that are developed to ensure that, again, protected activity and employee protection provisions may remain a central tenet of their culture. But nevertheless, the opportunity exists for gaps in the interface of those programs to create error traps related to inter and intra-organization communication, historical records and databases, employee records, human resource policies, and the routine conduct of a company's business under a license granted by the NRC. And when realized, these gaps may result in discrimination against employees for engaging in protected activity. And I'll tell you why that's important in a moment. But that's one of the foundational principles of our discussion today, is that those gaps result in a discrimination issue if the stars so align. So there are multiple lessons learned across the industry related to the nexus of that protected activity, of employment decisions by management, and other associated discrimination activities. Personal and professional consequences for taking those kinds of actions are severe for both individuals as well as for the licensed organization, the company that's controlling the work or that holds a license with the NRC. And those consequences are established to reinforce the importance of protected activity, why it's important to protect and to foster that safety conscious work environment, the healthy culture, ultimately focused on protecting the health and safety of the public. And I believe that an awareness of the consequences and repercussions of those items, it needs to be expanded across the industry. The knowledge base on these topics is deep, but I would argue that a general understanding of the specific circumstances that often apply can be improved through increased communication on historical case studies and more personal testimony. And that's why I'm here with you today. I want to share my experiences and lessons learned in this area in the hopes that I can help others understand the gravity of employee protection and protected activity. While I was serving as the procurement director for Vogtle 3 and 4 construction several years ago, I released a rehired contract employee who previously raised quality and compliance concerns, and that action caused an investigation by the NRC and the Office of Investigations. And in settlement out of that investigation, I entered into a confirmatory order with their Office of Enforcement. And one of my commitments out of that confirmatory order is to share my lessons learned and to share my story with folks throughout the industry who can benefit from what I have learned, and how I can help share the message of why it's important to properly take the right actions and to manage through protected activity and employment protection. So with that said, we'll move into our first slide here. So again, as nuclear professionals, we're committed to maintain that SCIWI, that healthy, safety conscious work environment where everyone, whether you're a contractor, whether you're an employee, where you feel free to raise concerns without any kind of fear of retaliation, harassment, intimidation, or other discrimination. It's a privilege to be able to raise those kinds of concerns, and it's a privilege to do so without fear of retaliation. And that privilege extends, again, like I said earlier, not just to employees of the company, quote unquote, the company. We're talking your subcontractors, your sub-suppliers, the people providing material to you, any consultants that may be tied into the work, anyone that's touching work that is done under a agreement regulated by the NRC is extended that privilege by default of them being on your site and being a nuclear worker. And there's a few key points I want to make sure that you understand are crucial in a leader's effort to support and maintain that healthy culture at your work location. I want to review this with you today and highlight the importance of protected activity and associated employee protection provisions that you may or may not have already institutionalized at your site or your work location. We'll talk about the importance of employee protection. We're going to talk about the criticality of follow-up on events and issues that may happen as you're having to make employment decisions around. We're going to talk about the criticality of follow-up when you evaluate adverse decisions, termination type decisions, demotion decisions, hiring, firing decisions. We'll go through a few historical examples, and then we'll kind of close it off with the lessons learned and the big picture takeaways. So the concepts of protected activity and employee protection are outlined in multiple sections of the federal code as it applies to licensing, construction, operations, and then also decommissioning of commercial nuclear power facilities or other nuclear related services that are governed by those sections of the code or operated or constructed under a license issued by the NRC. And broadly, those concepts are defined in parts 50 and 52 of the Code of Federal Regulations. 10 CFR 52.4 outlines deliberate misconduct for new nuclear power facilities operating under a combined operating construction license. 10 CFR 52.5 outlines the employee protection provisions for those same facilities. And then 10 CFR 50 sections 5 and 7 outline the definitions and the requirements behind deliberate misconduct, what that means, how that looks, and employee protection. So if you want more detail there, lots and lots of pages in the CFR around these topics, but that's the foundational material you need to kind of understand as your textbook when you're trying to determine the nexus of employee protection with protected activity. A lot of the topics here, it's critical to note that those protections under those different sections of the Code of Federal Regulations, they're afforded to all employees, regardless of their status with the company, whether they're full-time, part-time. And I think it's important to highlight that point for you one more time. The guidelines, protections, and rules, they're going to apply equally to all these employees, regardless of the legal relationship you may have with those individuals as a company or as the employing entity. And it's important because that's different than many standard HR policies that exist across the industry, whether it's commercial nuclear or non-nuclear activities. Human resources policies may define an employee with a very specific set of rules. Where does their paycheck come from? If it comes from another corporation, then they're not your employee. Well, under the employee protection provisions, if that employee is supporting the project that is licensed by the NRC, they're included in the population of an employee as it pertains to employee protections. So again, different definitions for different reasons, but it's important to understand the nuances and how they will apply on a nuclear site, where it's construction, operations, what have you, versus a non-nuclear site, okay? So with that said, the folks on the call that are nuclear workers and that have a deep nuclear or even any nuclear background, you may know some of these definitions here, but I want to run through kind of high level for you what some of these things really mean in layman's terms. So the by the book definition is what's going to matter when you discuss regulatory compliance to these different activities and the enforcement action that may be taken by the NRC as a result of a violation of any of these provisions. So we talk about protected activity, we're talking about writing condition reports. For the non-nuclear folks on the call, we're talking about identifying issues in the plant or in the construction site that just are of a concern for any nature or reason that you may have on your mind. Reporting concerns through a formal program, whether anonymous or not, or the communication through other means of any kind of information related to violations of any code or any requirements that are governing activities that are being conducted by your company under a license from the agency. Some specific examples would include an employee notifying his supervisor, their management, or their employer, or the NRC of an alleged violation of an NRC requirement or of a nuclear safety or a nuclear quality concern. Another example would be someone refusing to engage in any practice made unlawful by the Energy Reorganization Act of 1974 or the Atomic Energy Act of 1954, if that employee has identified that violation to his or her employer. Another item example would be testifying before Congress at any federal or state proceeding regarding any provision under the aforementioned Reorganization Act or the Atomic Energy Act, and also providing the NRC with any information about possible violations of requirements. Again, these are important because you want to make sure employees feel free to elevate these concerns. If they have an issue they may feel may impact nuclear safety, that may at some point result in exposure of the public to some type of rad material, they have a duty to act and a duty to share these things with the regulator, and doing so is considered a protected activity under the statutes and codes. An additional item or example of protected activity would be requesting NRC action against his or her employer for the administration or enforcement of requirements under the act. If you feel that the employer is not adhering to the guidelines, that's a protected activity to act, to notify the NRC. Furthermore, testifying in any legal proceedings, including before the NRC or before any other Department of Labor regarding nuclear safety issues or concerns from employees. And another example would be commencing or participating in a proceeding under Section 211 of the Energy Reorg Act of 1974. Next item here, we'll talk about adverse action. So what's an adverse action? So an adverse action is defined as a discharge or other action that relate to compensation, terms, conditions, employment privileges. This most commonly will take the form of a job reassignment, of a compensation adjustment, removal of privileges, special treatment or lack of special treatment, hiring decisions, or termination as well. The next item we'll talk about for a moment and define for you is discrimination. Discrimination is defined as taking an adverse action, discussed a moment ago, because an employee engaged in protected activities. The NRC may presume that an adverse action taken by management or by an employer was taken for a discriminatory reason, where the reasons for the decision were not consistent and well documented. In addition, the NRC may presume that the protected activity that conducted in the past played at least some part in the adverse action if the protected activity occurred before the adverse action was taken and the decision maker was aware of that protected activity. So what all that's trying to say is that the history of an employee's protected activity, the history of that employee raising concerns and bringing issues to management is very relevant in the terms of present day space around protected activity and around any adverse action that may be considered or is under consideration by management. Enforcement action, the last item on the page here, will take the form of confirmatory orders to adjust behavior that ensures compliance with the codes and regulations. Could also include civil penalties and fines. Could also include termination of access rights to facilities licensed under the NRC or other facilities governed by the NRC. And at the far end of the spectrum could also include criminal penalties, including incarceration or time served based on the severity of the actions and the results of those actions. So a wide range of activities and a wide range of consequences that may be tied to the severity of those actions if determined to be discriminatory. All right, next slide. So part of the shared commitment that we have as leaders in the industry and as leaders on nuclear projects and nuclear sites is promoting and pushing that strong, healthy safety culture among leadership, among associated contractors to perform work or oversee work that's safety related. You need to consider what processes you may have in place at your site, or if you're considering starting a nuclear project or a nuclear endeavor. whether it's maintenance activities, working in a maintenance contract for an operating site, whether it's decommissioning activities. That really, I know, is kicking up right now with the way the industry is moving. Decommissioning is equally covered under these statutes. But consider what kind of processes you have in place within your org structure to prevent retaliation and discrimination against individuals for raising those kind of safety issues we discussed previously. You know, consider the process for how you consistently document reasons for actions that may be taken that could be considered adverse employment actions. You know, if you're responsible for supervising or managing a team or managing a contractor, this material applies to you. If you view or if you see a report from your station or from your project site, any kind of roll-up of the condition reports or of the adverse action or concerns reports, this information applies to you. You know, that protected activity is all around you as a leader in the nuclear sphere, especially in construction. There's so many more people that can touch the safety-related components in an operating plan, and it requires you to have a much broader understanding of the definitions and of the whys around protected activity, and when an employee is engaged in protected activity. You know, so you need to really, I guess, take the time to stop and vet any type of decision that you're going to make around an employee's status, around any special privileges or any kind of pay, compensation, or employment status. You need to make sure that you take the time to stop and vet those decisions with the appropriate management personnel. Consult with human resources to make sure that they understand the spot that you're positioning the company in as a leader that may make a decision that may impact the company. Again, these discrimination findings, when they happen, can result in civil penalties and fines for the company and fine for individuals as well. You know, think back to your processes. Do you have a process in place that allows you to check on protected activity that an employee may have engaged in as part of your personnel adverse action kind of check off and checklist? And do you know who you would call to start that conversation? You know, so you need to carefully consider, if you're already in the business, refresh yourself on what your processes are. If you're trying to get into the business, understand you need to have these as a fundamental component of your org structure and your policies for managing your people. And if you aren't involved in the industry, these are some good things for you to think through as you decide to get into or join any type of nuclear construction or new nuclear effort. So I want to go through a couple of examples for you here. These are some specific examples of where an adverse employment action taken by an employer or by a company, where the NRC found a nexus to an employee's protected activity and identified the adverse employment action as discrimination. So we'll talk about some pretty obvious issues on some of these and the more subtle items that also factored into the decisions here, into the NRC's findings. You know, like anything else, it's not always as cut and dry as you might expect at first glance. And that's why it's so important that you have a thorough knowledge of the facts, you involve the right organizations, and you involve the right individuals in any kind of decision where there may be a nexus to protected activity when you go to take an adverse employment action. First example is releasing a contract employee who had raised safety quality concerns in a prior assignment after a break-in service. This was at Vogtle 3 and 4 in 2017. And this is the specific example that I'm bringing here to talk to you today about, led to my confirmatory order. Another example was that from the Byron Station, Byron 1 and 2 in 2002. In this individual situation, there was a candidate who would apply for an open position within the team and was denied or wasn't given the job because there had been prior safety concerns, and there was documentation and emails back and forth, basically where the hiring manager said, we're not going to give this person the job because X. Definitely a violation of the issues there. It's a no-no. Third example would be related to performance ratings and performance appraisals. There was an example at the Point Beach station in 2004 where an employee was given a negative performance appraisal, and it was documented as such in the appraisal that they were getting a negative review because they had previously raised safety concerns. Fourth item example here, kind of showing this is broader reaching than just operating plants or construction sites. This is from the research reactor at the University of Missouri. In 2001, the NRC concluded that a former research scientist was subjected to employment discrimination and retaliation by management of that facility because they raised safety issues over a period of years. And I think that I want to leave you with on this slide that the burden is on you as the decision maker or the manager to document and demonstrate that any protected activity that the individual may have been involved in, is involved in, was involved in the past, it has no relation to or is in any way related to the reason for the action that's being taken that's considered adverse. Again, back to termination decisions, pay decisions, special privilege decisions, those types of things. So I'll leave you with a real simple tip. You know, how do you prevent these things from happening? Well, you know, fundamentally, if you're a nuclear worker, you know what STAR means, right? Stop, think, act, review. You know, think about what you would do if you're in a position where you're considering adverse action. You want to make sure that you process what the decision really means. You engage with the appropriate staff, and you take a full picture of the employee's history of protected activity into consideration. You know, it's also important to understand that the more you can make sure you treat all your employees and your contractors the same way in a fair and equitable manner when it comes to special privileges or treatments, or even just in general, your daily interactions. If you've taken an adverse action against an employee for engaging in a behavior that other employees routinely get away with or can do without any negative consequences, understand that could also be considered a discriminatory action. So again, high level, you want to make sure that you consider your policies for addressing adverse actions. Make sure that any documentation that you've got around the basis for that decision is sound and solid, and it supports your decision that you're starting to make. Make sure you consult appropriate departments inside your company to make sure you make the right decision and let them help you make that decision. And then again, consult with HR to request a review of that specific situation by the right leadership to help you get some advice on the next steps. Those items could be review your concerns program for protected activity, conduct a review of your condition report program, and also maybe refer those results to a body. Some sites have actual bodies or boards that they use to help review adverse actions as they may be tied to protected activity to prevent discrimination from entering into their workforce and help maintain that safety conscious work environment and keep fostering that healthy nuclear safety culture. So I've covered a lot of material, real broad swath around protected activity and employee protections, try to give you some definitions. You know, we can take a minute here, Jenny, if you like, and take any questions we may have from the group. Got a couple of items on the board here to kind of help you remember, you know, what are some of the major talking points around what your takeaways might be, but I'll be happy to take any questions you may have before we close out the conversation.
All right, Tom, have a question here. Why is this material relevant or important to CII's membership?
That's a great point, Mike. And you know, I think that for the broader industry, which CII is kind of a broad cross section of companies and contract companies, you know, it's critical for you to recognize how industrial safety and how personnel safety is different from nuclear safety. And there's special requirements, just like the special requirements for industrial safety regarding fall protection, regarding PPE usage. There's also special requirements around personnel protection when it comes to protected activity. And unless you spent time around nuclear projects or nuclear job sites, operating plants, or construction or decommissioning, it's going to be new to you. And unless you've been indoctrinated in that culture, and if you've been around a healthy safety culture, it's very important, you're going to have a hard time understanding the nuances of this topic. And I think that whether you're an individual contributor out there listening, whether you're a supervisor, department manager, or maybe the senior executive responsible for a whole project or an entire organization or job site, a firm grasp on these just fundamental tenets of employee protections and protected activity is really just a basic building block of a successful career as a nuclear worker. So for folks that are in the business today, or they want to be in that business, these are just fundamental items that I hope, if you haven't already learned about them, you would take the time to go do so after our discussion today.
Okay, thanks. What will you do differently if confronted with a similar situation in the future?
Oh yeah, so if we go back a couple of slides, I think that STAR kind of sums it up. If you're a nuclear worker, you've been through and recently human performance tools have transcended from nuclear into traditional, for my case, utility generation aspects. I know that several years ago for Southern Company, we rolled out the nuclear human performance tools across our fossil fleet and saw some good gains in attention to detail and just in overall employee behaviors. And one of those tools is STAR: stop, think, act, review. Stop for a moment, consider what you're going to do before you do it. Think about the implications of that decision. Consult with the right third parties, with the right teams, the right support structures to help vet your decision, to help make sure that it's lined up with your company's philosophies and principles, and most importantly, is not going to violate any of the Employee Protection Acts and provisions that exist in the Code of Federal Regulations. And then you take the action, right? You follow through with the action based off that review and that pause. And then you come back and you assess your action and make sure that you had dotted all your I's and crossed all your T's. So stop, think, act, review is one of my key takeaways that I will leave you with in this situation for anybody out there that may be in the same kind of boat.
Okay, thank you. Do you have any insights on how international projects differ from those in the U.S.?
I mean, fundamentally, the projects in the U.S. are going to be licensed by the U.S. NRC, and I know different international countries would have different governing bodies. And I will tell you that you would need to have a thorough understanding of whatever license the international project is operating under. If they've been given a license for a nuclear project by that country's nuclear regulatory agency, I've got some experience with the AP1000 China plants that Westinghouse helped a couple of different change utilities build, the Sanmen and Haiyang stations, and they have a regulator, just like the United States is a regulator. I believe it's the NNSA, the Chinese NNSA, I think, but a very similar structure. They've got on-site inspectors, and they have folks that they have certain things they're looking for in the construction processes. But I would tell you that the rules, fundamentally, they'll all be based around this healthy safety culture and a healthy, a strong SCIWI. But the specific nuances of the requirements, I would tell you, are going to be different, and you'll need to consult with some legal counsel or some specific folks, your licensing personnel that would know the nuances of your license in the international countries and know how that applies back to whatever governing codes that may exist in that country. But I'll tell you that the U.S., we have a high bar here. The NRC is the top tier in the world. I've been in lots of discussions where, international contingents will come to Vogtle to see what we're doing here and how they can take it and apply it to their country. And I know the NRC in those conversations, the NRC has been asked to come in and help other countries establish and set up their nuclear regulatory bodies. And so the NRC is looked at as kind of a beacon across the world as far as the top tier expectations go of what good looks like. And so I would tell you, if you adhere to the NRC's expectations, you'll be in good shape for the other countries. But again, check your local laws, check the regulations and the codes before you make any decisions. But I would expect if you can do what the NRC expects you to do, you should be acceptable in the other ones. But again, it's going to be nuanced based off your specific international location.
Okay. In the interest of clarity, is there a duration of time after a protected activity where it becomes less relevant to other employee actions in the future? How far back should records be kept?
That's a great question. I'll tell you from my chair and where I sit and what I've seen in my personal experience, there is no statute of limitations. I mean, there's the one major takeaway for the group, and whoever asked the question, that's a great question. You've got to operate in such a way that you take a very broad view of the timing of any protected activity compared with the timing of any adverse action. For me personally, I was on the job site when this individual that I was, the decision was made around, worked on the Vogtle construction site years ago in a totally different capacity, totally different role, not even in the same company. But I was aware of the issues, right? I was aware of the fundamental, issue that was raised. I knew that it existed. And fast forward years and years later, a whole different company, a whole different role, and that same protected activity is what was determined to have a nexus to the decision in this situation. So, I would tell you, take a broad view of the timing of that protected activity and make sure that you put that in context when you are making any relevant decisions on personnel. Very important. Yeah.
Thanks. One viewer says, I can relate to the subject as it relates to process safety in the oil and gas industry. Also, the importance of leadership and behaviors alongside the setting and adherence to procedures. What are your experience of the similarities across high hazard industries?
I'm reading it again right here on the screen. I think that it goes back to behaviors. You bring that up in the question here, and I think it's around snap judgments and making quick decisions. At times it's when you're expected to make a quick decision and move on with something and put it behind you and go on to the next issue. And a lot of these big projects and major big capital jobs, if you're in a senior role, you got 1,000 things coming at you every day. I've been there, done that, lived it for years. You've got to prioritize very quickly what you focus on and where your time is best spent. And what do you delegate to others? What do you do yourself, right? So, regarding your behaviors and leadership behaviors on adhering to procedures and processes, make sure that you have a process, make sure that you have a procedure. How do you handle these types of things? Without, in the absence of having that guidance, leaders and management are going to make their own decision. If you have someone that's a high D on the DISC scale or has a very strong personality, they're going to drive through, make a decision, and keep going and check up later, maybe. Well, in this type of situation, you've got to help check that kind of person to help them not get into trouble. And you owe it to your organization to help establish those kind of processes and procedures so they do exist to help prevent your company, your leadership from getting into issues, and also to help your employees, prevent your employees from being exposed to potential discriminatory action from management. So your question is very relevant, and I will tell you the simple answer is make sure that you have processes and procedures to address these types of issues.
Thanks, Tom.
Sure.
That looks like all the questions we have. Give you a few seconds here if anybody else has a question they want to submit.
And while you might be thinking through any final questions from the audience, just kind of, want to run through with you, leave you with the key messages. What's in your head as a leader when you make an adverse employment decision regarding behavior or performance won't be considered conclusive in the discrimination determination. The circumstance of that specific incident has got to be considered within the larger context of the employee's history of protected activity. Back to the prior question, history is important here, right? Make sure you seek input from others is the key lesson learned there. Additionally, the consistency of your performance documentation that separates performance issues from protected activity is also necessary. There's got to be a separation between those two issues such that if there's a reason you're making an employment decision based off of performance issues, it's got to be very clearly documented and defined how those performance issues are not related to any current or previous protected activity. Very important. Also, consistency of how you treat everyone in similar situations is also critical. Fourth item I'll leave you with, the definition of protected activity can be interpreted by the NRC to expand beyond safety-related items and into anything that could influence someone's willingness to report a nuclear safety issue, as it might apply to construction projects, commercial nuclear construction projects. Just because there's some work being done or issue identified on a non-safety related portion of your project or plant or your endeavor, for instance, items that have no nexus to nuclear safety, that aren't required to be constructed under the NRC specific guidelines for safe shutdown of the plant during a reactor issue. Like at Vogtle, for example, on our secondary side, our turbine building, all of our feed water systems, the items around the plant outside of the nuclear block itself, any item that may happen in those areas that would influence someone's willingness to report a nuclear safety issue could also be considered protected activity. So don't let the safety related work kind of black and white line influence your definition of protected activity. Fifth thing here I want to kind of drop with you, again, factor a broad view of protected activity as well as a broad view of the timing of that activity versus the timing of the adverse action into the decision-making process. And, make sure to maintain a healthy, safety conscious work environment in your organization and to avoid any consequence tied to an enforcement action. Again, to the prior question about what processes and procedures in high hazard industries, make sure you take considerations to protect yourself, your company, and your employees so that you've got the right types of structures in place ahead of any type of adverse decision needing to be made when you have the opportunity to have had protected activity occur.
Okay, we have couple other questions here. One, how significant is a questioning attitude in the nuclear industry?
Yeah, I will tell you that we've got a saying, and I believe it comes from one of the info guiding documents we kind of put at the core of our management behaviors. A questioning attitude is cultivated. And I will tell you that the more you can encourage that type of behavior from your staff and from your organization, the more you demonstrate that yourself as a leader. Again, the more you can model these behaviors to the workforce and to your teams and to your employees, they're going to want to emulate that and do as you do, right? And so the more you cultivate that questioning attitude, you draw challenges out of people. You have to encourage open challenge. You have to encourage the conversation between employees and management and engage in a healthy, constructive dialogue. It may not be, nuclear is not for everybody. There's a high high level of interaction and engagement required in this business, and there's a high level of tolerance for, another thing we say, feedback is a gift, right? You say that in my non-nuclear experience, back when I first started out of college, okay, you say that, but in nuclear, that really is a fundamental operating principle, is that feedback is valuable to help you get better and improve. And when it comes to fostering that environment, if you don't ask the question around why something isn't, why is it okay to do something, you're never going to get any better, right? So, the question, how significant is it? It's one of the founding principles of what INPO stands for. So yeah, very, very important. And I see the one more here difference between contractors and staff. So when it comes to this topic, there is no difference. I think that's, again, critical takeaway. Just because someone is a contractor, that may be the vehicle that they are employed under from a legal standpoint, from an employment law standpoint. That doesn't mean that there are different rules that apply to that individual's actions or your actions as a leader or manager or an executive over decisions that impact that employee, whether it's a contractor, whether it's full-time employee, part-time employee, whether it's the person that stocks the vending machine that may overhear a conversation that thinks this is an issue. People coming on the site that have access to the job site, they are nuclear workers, and their legal employment status is irrelevant when it comes to the definition of protected activity, employee protection provisions, and how the regulator will view any adverse actions taken that have a nexus to protected activity. So there's no difference is the answer to that question.
Okay, well, that's all the questions we have for today. Thank you very much for joining us. We appreciate your time, and we hope that you found the webinar useful. I'd like to thank you very much, Tom, for your informative presentation. Don't forget to check out our events page to sign up for future webinars. Stay safe, and we'll see you next time.
Thanks, everyone. Thanks, Mike.
Thank you.